Welcome to this RE5 exam preparation lesson. In this video, we'll cover Topic 1, General FAIS Information. You'll learn what FAIS is, how it changed the financial industry, the different FSP license categories, and the financial products defined under FAIS. What is FAIS? FAIS stands for the Financial Advisory and Intermediary Services Act 37 of 2002. FAIS Act 37 of 2002 was signed into law in 2002, but the act only became effective September 30, 2004. At the time, existing financial service providers had until June 15, 2004 to apply for a license. The purpose, or rather purposes, of the FAIS Act 37 of 2002 are as follows. Consumer protection. The Act aims to protect consumers from unscrupulous selling practices and inappropriate advice concerning financial products like insurance, investments, and deposits. Industry professionalization. It sets a professional code of conduct for all authorized financial services providers and their representatives. Licensing. All FSPs must be licensed to provide financial services and must comply with specific fit and proper requirements, such as competence, honesty, and integrity. Regulation. The Act requires that representatives pass a regulatory examination, RE5, to ensure they have the necessary knowledge of the legislation. Enforcement. The Financial Sector Conduct Authority, FSCA, is the regulatory body responsible for overseeing the Act, and there is also the Office of the FAIS Ombudsman to handle complaints from consumers. South Africa's FAIS subordinate legislation includes regulations, rules, and codes of conduct created under the Financial Advisory and Intermediary Services, FAIS, Act 37 of 2002 to provide detailed guidelines for financial service providers, FSPs. The FAIS Act is the primary law setting out the broad framework. The subordinate legislation, codes of conduct, notices, etc., provides the specific rules and procedures that FSPs must follow to comply with the Act. The FSCA, as the regulator, is responsible for enforcing both the Act and the subordinate legislation. Additional requirements are outlined in subordinate legislation and include conduct standards under the FAIS Act require financial services providers, FSPs, to act honestly, fairly, and with due skill, care, and diligence in the client's best interest. These standards also mandate that information provided to clients must be accurate, clear, and in plain language, with disclosures about conflicts of interest. There are specific conduct standards for different areas, such as collective investment schemes, CS, managers, and banks. FSCA FAIS notices are legal notices published by the Financial Sector Conduct Authority, FSCA, that are used to implement, amend, or provide exemptions under the Financial Advisory and Intermediary Services, FAIS Act. These notices specify various requirements and exemptions for financial services providers, FSPs, in South Africa, such as withdrawals of authorization, exemptions from specific sections of the Act, or details on fit and proper requirements. For more info on this, head to the FSCA website. Directives under the FAIS Act are issued by the Financial Sector Conduct Authority, FSCA, to ensure compliance with the Act and its associated codes of conduct. These directives can be issued to specific individuals or generally, and may require the recipient to stop an undesirable practice, correct a non-compliance issue, or submit an action plan. Failure to comply can lead to penalties, and the FSCA can refer the matter to the Enforcement Committee. The FAIS Act requires financial service providers, FSPs, to act honestly, fairly, and with due skill, care, and diligence in the best interests of their clients and the financial industry's integrity. The General Code of Conduct provides more specific rules, mandating that providers ensure all information is factually correct, in plain language, and adequate for the client's level of knowledge. Providers must also manage conflicts of interest, make appropriate disclosures to clients, and maintain proper records. Guidance notes for the FAS Act provide specific interpretations and practical advice on applying the Act's regulations, often clarifying requirements for financial services providers and their representatives. They address various topics, such as the responsibility of an FSP for its representatives, the requirement for representatives to act in the FSP's name, and how to comply with the fit and proper requirements. Board notices under the FAS Act provide specific regulatory details and are issued by the Financial Sector Conduct Authority, FSCA. Key examples include Board Notice 194 of 2017, which details the fit and proper requirements for financial services providers, and earlier notices that establish and amend qualifying criteria, qualifications, and continuous professional development, CPD. These notices define specific requirements for financial service providers, such as competency, experience, and professional conduct, and also include notices of exemptions for certain providers from specific requirements. The regulations for the FAS Act, officially known as the Financial Advisory and Intermediary Services Act, 37 of 2002, are outlined in the Financial Advisory and Intermediary Services Regulations, 2003, and the Determination of Fit and Proper Requirements. These regulations detail the requirements for financial services providers, FSPs, including honesty, competence, operational ability, and solvency, and mandate specific actions like obtaining a license, providing appropriate client advice, and establishing internal compliance functions. Thank you for watching Part 1 of this lesson. Part 2 will follow soon. Please like, share, and subscribe. Hit the notification bell.